So please introduce yourself.
So my name is Gauri and I'm coming from Noida in Uttar Pradesh. I did my entire education from Delhi, and in school I was a humanities student, so that's how I developed an interest in law, and then I went on to do my BA LLB honours from NLU Delhi, and I graduated from there in 2019, and I've been preparing for judicial services since then.
So you've done your law in 2019?
Yes, sir.
And since then you are preparing?
Yes, sir.
So have you taken any other exams as well apart from Haryana Judiciary?
Yes, sir. I recently appeared for Delhi Judiciary's exam.
Okay.
And I also just appeared for Madhya Pradesh mains as well.
MP. And?
Before this I've given some other exams. I cleared the mains of those exams, but I did not make it to the final selection.
So which is your focus state? Where exactly you want to be settled?
Sir, I'm fine with both Haryana and Delhi because...
Then why you have taken MP Judiciary exam?
Sir, because the form came about at the same time when I was preparing, so I thought I'll give it for practice.
So if supposedly if you are selected in MP Judiciary, so you will be joining it or you won't be joining?
Sir, I think the Haryana Judiciary's result will come before that. So wherever I get selected first, I would like to continue there.
So have you done masters as well?
No, sir.
No. What was your dissertation topic?
We actually didn't have a dissertation in LLB. We just had regular projects in every subject. So,
So is there any inclination towards any particular subject?
Yes, sir. I like evidence law and...
You like evidence and?
CRPC also.
And CRPC. And how about the substantive law?
Substantive law, I like IPC.
IPC you like. So can you tell us, is there any provision for punishing a wrongdoer for keeping drugs under the IPC?
Under the IPC? Sir, I'm not exactly able to recall it. Under the IPC, I'm aware of only the NDPS Act.
Okay. So what do you know about NDPS Act?
Sir, in one of my internships, I had researched a little bit on the bail provisions in NDPS Act, and the offences under that depend on, and the penalty and the bail provisions depend on the quantity of the drugs that is found on the accused, whether it is small quantity or commercial quantity. So I had researched a little bit about that. Yeah.
Okay, so what is the difference between a murder and death by negligence?
So the basic difference is in the mens rea. So in case of murder, there is just intention to cause death, or intention to cause bodily injury that is sufficient to cause death, etc. So the clauses of section 300, basically intention or knowledge has to be proved. Whereas in case of death by negligence, there is neither intention nor knowledge. It's negligence means basically lack of that foresight, or lack of the ability to foresee what are the consequences, or foreseeing it but still going ahead with it and then committing an act which ends up causing death.
Can we convict and accuse for both the offences under
no, they are
304A and then...
no, they are mutually exclusive, because if you are saying that there is intention then, or intention or knowledge, then it would go under murder. If there is no intention or knowledge, then it's 304A. In fact, the language of 304A itself states that it excludes the applicability of this mens rea.
So 304A uses the term negligence. So does it mean only a simple negligence or a gross negligence?
It refers to gross negligence.
So in every case, gross negligence is required?
Yes.
Is it?
Yes.
So why have the legislature written only the negligence one and gross negligence then?
Sir, the term gross negligence is actually evolved through judicial interpretation, because I think in a lot of times this is used to penalize doctors' professional culpability. So in those cases, courts have pointed out that there may be a situation where a person, by means of just an error of judgment or some kind of a casual mistake, at times that person may end up causing death. So to avoid such people getting caught up within the ambit of 304A, courts have actually inserted the word gross into it's a judicial interpretation basically.
And how about the difference between dowry death and murder?
In case of dowry death, there is it is like a murder only, or it could also be death due to...
Can we punish the accused for both the offences?
I am not exactly aware of that, sir, but there could be certain situations within 304B which are not explicitly covered under the definition of murder. For example, if the death occurs due to accidental causes, or if clearly intention or knowledge has not been proved, or even in fact 304B has been interpreted to even cover suicide cases. Anything which is not just homicide could include any of those other situations.
But then homicides are also covered under the dowry death, is it?
They are covered under it.
So can we convict both?
I'm not entirely aware of that, sir.
So what is the difference between cruelty and can we convict the accused for dowry death and cruelty both?
Yes, sir. The cruelty is included within dowry death.
So can we convict an accused for dowry death without cruelty?
Yes, sir, that can also be done because the punishment for dowry death is anyways more than cruelty, and it includes within its ambit the offence of cruelty as well.
So you are saying that dowry death includes cruelty?
Yes.
So my question was, can we convict the accused? Can we convict an accused for dowry death without convicting him under cruelty?
If we can do so, there is no bar to it as such. But generally, the cases that I've seen.
You are saying that cruelty is a part of the dowry death.
Yes, sir. But
so
that's.
If dowry death has to be proved, then cruelty is
automatically
requirement. And then if cruelty is proved, then the accused has to be punished under 498 IPC as well?
Yes, sir. That's what I think. In most of the cases that I've seen, they're convicted under both. So I think that should be the position.
So you said you like CRPC and evidence also.
Yes.
Who has written Indian Evidence Act?
Sir, it was Mr. James Fitzstephen.
Sorry?
I'm not exactly able to recall the exact name right now.
And you said CRPC is also your favorite subject.
Yes.
Which, if we ask you the chronological order of CRPC, which exactly number, like the current CRPC which we are having is 1973 CRPC.
Yes, sir.
Before that, how many laws were passed for the criminal procedure?
Sir, I'm aware of the CRPC of 1989. Other than that, I'm not aware of any other laws on criminal procedure.
And can we, do you know the law on additional prosecution?
Yes, sir.
Can you please explain?
It's given under section 319 of CRPC. So basically at any stage of inquiry or trial, if the court is of the opinion that any person other than one who's already accused before the court may also have committed the offence, then the court can proceed against that person. So the purpose of this power is basically that if the investigating authority has left out anyone from being charge sheeted, then the court is not precluded from proceeding against that person.
What if an accused was, mentioned in the FIR, but he was not actually charge sheeted? Can we, at the trial of the other accused, other co-accused, can we include the other, the left accused under section 319?
Yes, sir. The court has the power to do so if his role is clear from the police report and the other evidence.
What exactly has to be examined by the judicial officer for initiating additional prosecution proceedings?
So there has to be something more than just a prima facie case. That is what the
prima facie case evident from
the evidence before the court during inquiry and trial.
During inquiry and trial, but if there is no as such direct evidence against the person whom to be added in the trial, so can the judicial officer still solely on the basis of the previous FIR? Can he? If
the judicial officer has some additional doubts, the officer can also resort to section 165 of Indian Evidence Act and ask questions or summon that person and examine him and find out more information, and then based on that the officer can decide.
Do you know the latest law on mutual divorce?
Latest judgments, I'm not aware of any. I'm not able to recall.
Do you read judgments?
Yes, sir. I try to read judgments, recent judgments.
So Gauri, right? Okay, so Gauri, you said that you are interested in IPC. Okay, so have you gone through the judgment on Upto Singh Johar? Okay, what was the decision of the court?
The issue before the court was the constitutionality of section 377, and basically the court read down section 377 to exclude, to decriminalize homosexuality. The reasoning given by the court was that the way 377 is worded, it criminalizes consensual sexual acts between adults, and it in that manner it violates Article 14, 15, even the right to privacy, which is a part of Article 20.
Consensual sexual acts between all the adults?
Yeah, between adults.
Between all the adults? Yeah. Okay. Then how will you explain against the order of the nature?
Yeah, so that was the terminology that was used there, because 375 was exclusively applicable to just consensual, non-consensual sexual acts between men and women, whereas 377 was mostly invoked in case of same-sex relationships.
Then not
So,
between all the
yeah,
adults.
not yeah, same-sex
Okay.
relationships.
Then can homosexuals legally get married in India now?
Not as of now. So there is a pending writ petition regarding that before the Delhi High Court, and the High Court is looking into that matter, right?
Okay. All right. And is a judge or judiciary bound by the police reports?
No, the court is not bound by a police
Can
report.
you tell me any judgment?
Bhagwan Singh versus Commissioner of Police.
Okay. And what is the evidentiary value of a tainted evidence? Is it admissible in the court?
By tainted evidence, are you referring to evidence that was obtained
By
illegally?
tainted sources.
Sorry?
By illegal means.
By illegal means, the court can still rely on it if it is admissible and relevant as per the criteria under the Evidence Act. There is no bar on relying on it.
Okay. And what is the role of public prosecutors in the court?
Public prosecutors represent the state in a criminal trial, because every offence is deemed to be an offence against the state. In criminal cases, offence.
So are public prosecutors also bound by what the state tells them?
They are required to exercise independent decision in taking certain matters. For example, when it comes to withdrawal of prosecution, etc., the state may advise them to withdraw it, but they are required to exercise their mind independently and see whether it is in the interest of justice to actually withdraw the proceeding or not.
Okay, all right. So who is the Chief Justice of Haryana currently?
It's Justice Ravi Shankar Jha.
And who was the first Chief Justice of Haryana court?
It was Justice Mehar Singh.
Okay, all right. Are you sure?
After the Punjab and Haryana High Court was constituted in 1966, it was Justice Mehar Singh.
Okay. And what was the theme of 75th Independence Day of India?
Azadi Ka Amrit Mahotsav, and then we had a flag, Har Ghar Tiranga initiative as well.
Are you sure that was the theme?
I'm not exactly aware of the theme as such.
All right. Okay.
So, Gauri, who is your favorite judge? You said you like reading judgments. So I'm sure ki you must be having some sort of an inclination towards a particular judge. So who is your favorite judge amongst the Supreme Court judges?
So the recently retired Chief Justice N.V. Ramana was my favorite judge. I think his style of writing judgments is very simple and very easy to read. Like even a lay person can read it, and even I as a law student can read it very easily. So I like his style of writing.
Sir, can you tell us few of his contribution in the judiciary?
So I think one judgment that he is very well known for is his judgment in Anuradha Bhasin's case. Anuradha Bhasin was the Union of India, the internet ban case. So there he discussed the way right to free speech needs to be balanced with national security concerns. So while recognizing that national security is a legitimate ground for curtailing free speech, he said that he invoked the doctrine of proportionality in that judgment, and he said that free speech cannot be curtailed in a in a disproportionate manner, not in a widespread manner. So internet bans, if they go on indefinitely over a long period of time over the entire state, they can it has a widespread impact on the right to use internet, which in turn affects other aspects of the economy, education, employment, etc. So the way he balanced these two rights, I think I really like that. And similarly, he is also part of the bench on the Pegasus case and even the sedition case, Wombad Kere versus Union of India. And in all these cases, I think the crux of the issue was this only, balancing right to free speech with public order or national security concerns. And here's the way he discussed the balance between the two is what I think I like the most about the judgments.
So recently, Honorable Justice UU Lalit have taken the charge as the Chief Justice of India. So do you know his contribution?
He was the chairperson of NALSA, so he had done a lot of initiatives relating to legal aid. And I don't recall any judgment that I've read of him at the moment.
What is the current strength of the Supreme Court judges?
It's about 30, I believe.
30. Okay. And what is the approved strength?
It is 34, including the Chief Justice.
Okay. And how about Haryana and Punjab High Court?
The sanction strength is 68, but at present they have 56 judges.
56 judges. Okay. So, do you know about the character evidence? You said evidence is also your favorite subject. Do you know about the character evidence? Okay. How it is relevant? Can you explain us the relevancy of the character evidence?
In civil cases, basically, character as a general rule is not relevant because the general rule is that the court should look at the merits of the cause of action and not the man who's before the court. But there are some exceptions to it. For example, when character itself is a relevant fact under any other provision, or when the character of the plaintiff is in question, which would determine the amount of damages that he may get. For example, in a defamation suit, the character of the plaintiff becomes a relevant fact because if his reputation was already low, he would get a less amount of damages. So in that case, it would be a relevant fact. In criminal cases, on the other hand, bad character of the accused is generally it's not a relevant fact, except where character is again it's becoming evident from other.
Against? Sorry?
Bad character of the accused is not a relevant fact.
Okay.
Yeah, but because then it's likely to prejudice trial. But good character of the accused is a relevant fact.
Good character is a relevant fact.
Yes.
In each and every case.
In criminal case.
So, Gauri, how can you contribute to the judiciary if supposedly you are selected?
Sir, I think
What will be your contribution?
I am someone who's comfortable with the use of technology, so I think I'll try and use technology wherever possible to speed up things. For example, after the pandemic, I think courts and lawyers and litigants have become more open to using video conferencing facilities. So I'll use that to, for example, examine expert witnesses or official witnesses who are living far away, and I'll also try and use these email etc. to serve summons, because again that is also something that takes a lot of time. So I'll use technology wherever possible to speed up things.
So, by using this kind of technology, you said you'll be able to contribute to the judiciary?
Yes, I think at my personal level, I think that is what I can do to speed up things, at least in my courtroom.
So, do you want to ask?
Yes. So Gauri, you said that you are from NLU Delhi. Okay. So you must have done a lot of research then, right? So how many papers have you got published?
I got one paper published as an independent author, and I worked on two.
What was the topic?
It was on marital rape as a ground for divorce.
Okay.
And then I worked as a student researcher on two books which were published by my teachers. One was on death penalty and another one was on reproductive justice in India.
Okay. Do you know who is Dr. Ranveer Singh?
Yes, he was our founding vice chancellor, and until recently he was our vice chancellor.
And also a founder of
Nalsar.
NASA. Okay. So do you think having good research skills will help you become a good judge?
Definitely. I think I've received a lot of personal feedback on my research and writing skills, and I think a judge communicates to the society through his or her judgments only. So I think it will definitely be helpful, the skills that I've accumulated.
Okay. And how will you tackle the problem of pendency of the cases apart from using the technology? Of course, you mentioned that.
I think there are several provisions that are given in our procedural laws which actually help in speeding up things. For example, I'll ensure that the provision of Order 17 CPC is strictly enforced. So I will not grant more than 3 adjournments, and I will also.
What if there is a reasonable excuse?
In exceptional circumstances, I will definitely use my discretion to allow it, because procedural law should not override the cause of justice. But if there is any unnecessary adjournment, then I will definitely impose costs on it also. Then even section 35B of CPC also allows imposition of costs where a party tries to delay unnecessarily. So these are some methods that I will try and use. And I think recently there was a judgment of the Supreme Court which asked the judicial magistrates to conduct examination in chief and cross examination on the same day to speed up again, because a lot of time lag often happens between the two. So I'll implement that also.
Okay. And how will you motivate the parties to undergo arbitration process?
I will inform them of what to expect and what are the advantages of that over litigation, and how they will save time, money, and it will also be confidential. And court fees will also be refunded to them if they are able to settle it, so that they approach it with an open mind, and they shouldn't just see it as a step before litigation. They should actually see it as an alternative to litigation.
Okay. Can you explain the difference between mediation and conciliation?
In mediation, there is a third person. Actually, in both, there may be a third person who's doing it. The difference is mostly in terms of the level of formality. So, conciliation is considered to be slightly more formal than mediation. And in mediation, the mediator meets each party individually, and then it finds out the confidential aspects of the case and then informs the other party. So, there are some minor differences like that, but other than that, it's similar.
Okay. All right.
Right, so thank you so much, Gauri, and we'll come to the review part now. So, पता है मुझे आप अच्छा बोलते हो.
मैंने कुछ कुछ गलतियाँ बोल दी थी, मुझे पता है. मैंने एक्चुअली वो हिंदू लॉ भी पढ़ा नहीं था, मेरा MP मेंस था, तो उसके बाद आके और एविडेंस भी मैंने थोड़ा वो गड़बड़ कर दी थी, मुझे पता बोलते टाइम था. हाँ,
एविडेंस में आपने
कैरेक्टर वाला पूरा गलत बोल दिया था, मैं समझ गई थी.
अच्छा, आपने बोला व्हेन वी आस्क्ड यू कि कंट्रीब्यूशन.
हाँ, उसमें क्या बोलना था मुझे,
आपने
उसमें डाउट.
कंट्रीब्यूशन में भी बोला था
सॉरी,
that
Through technology.
टेक्नोलॉजी, उसमें क्या बोलना था?
तो ठीक है, टेक्नोलॉजी यू कैन यूज, बट देन नॉट, यू कैन नॉट रिस्ट्रिक्ट योर आंसर ओनली टू टेक्नोलॉजी.
हाँ, मतलब मुझे वो क्वेश्चन
आप
थोड़ा
in
ब्रॉड
fact
लगा
इसके
था.
अंदर रिसर्च करो, रिसर्च वाला पॉइंट इसमें ऐड करो.
ठीक है,
Yes.
ठीक है, ओके, समझ गई.
That's why I had asked you.
Right.
Okay.
Because I'm hailing from NLU
Okay,
Delhi,
okay, I
I have good experience in research.
करेक्ट, ये आप बताओ.
उसमें बोल सकते हैं.
Yes.
एंड देन
मुझे एक्चुअली क्वेश्चन थी. हाँ,
ठीक है, दे लास्ट यू व्हाट काइंड ऑफ रिसर्च हैव यू.
तो बेसिकली वो हमारे यूनिक जो हम लोगों की स्किल्स
Yes.
है वो वहाँ पे.
तो आपकी यूएसपी है.
ओके, ठीक है, ठीक है.
ठीक है, वो तो एजुकेट नहीं है ना उससे, और वो तो छुपा के बैठे हैं.
वही वही मुझे भी एक्चुअली वो क्वेश्चन मैं आई वाज गोइंग टू आस्क अबाउट दैट, क्योंकि मुझे वो रिटन क्वेश्चनर भी समझ नहीं आता.
But the thing is कि whatever you're saying now, you're saying it too fast. You're just too fast with your answers. So maybe you're just answering everything, but everything is getting lost in transit. So I think that you have to go slow about the answers.
राइट. सो बाकी तो परफेक्ट है ना, यू हैव आंसर फॉर एवरीथिंग.